guests, but we have to continue because we haven't discussed the second part of the new regulation in Europe, and that's the new competition tool. I think we start. We have to start.
You're the moderator.
And maybe if they listen to us outside, they're going to come. I'm glad that despite the Corona restrictions and all the hurdles, Natalie Harsdorf could make it to come today to Berlin. We didn't have so much luck last year, and to talk in person the Amazon case with Silke Hossenfelder, but I think you have followed us last year, and this year you are in person here, and it's really a great pleasure. We have in our video call Ben Schroeter from Booking.com. We have Silke Hossenfelder from the Federal Cartel Office, and Marike Scholz from the European Commission. So we have three regulators with us, plus a potential gatekeeper, as we could learn from the previous comment of Louis. Ben is laughing. And I think the first question goes into the same direction as in the previous panel. Do we really have an enforcement gap that we really need a new competition tool? And we'll start with Natalie and then continue with Silke and Marike.
Yeah, thanks a lot for the nice welcome. I'm really happy to be here. First of all, it's nice to see colleagues again and travel to Berlin. And also, it's a nice format. I feel like it's a late night competition talk show. You're the host and I'm the guest. So that's really nice, something new. Do we have an enforcement gap? Certainly what the NCT would enable the Commission to do is something we cannot do at the moment. So we have enforcement under 101, under 102. We have the possibility to do sector inquiries. We have merger control. That's all something that is mirrored at the national level. Then we have in some jurisdictions, not only UK, also Iceland, if we think about Europe in the broader sense, that also has a similar tool. So they have something beyond that. What we see internationally and also within Europe is a growing discussion on a rise of concentration. We have a growing discussion on expectation towards what competition enforcement can achieve for the functioning of markets. And we see that we have some structural issues that we cannot really deal with to an extent that is perceived as sufficient or satisfactory with the current instruments.
What would be the appropriate threshold for intervention? I mean, in this respect, we have some kind of paradigm shift, Paradigmenwechsel, so to say, because we basically would like to act without finding any abuse.
Exactly. That's exactly, you're putting the finger on the wound, but on the other hand, also looking at it from a different perspective, we're discussing something completely new, because we're not looking for an infringement, we're not looking to go for a fine, we're not picking out a single company, we want to look at the structure in certain market sectors. We are looking at theories of harm. We have to see, is there a real problem? For example, with tacit collusion, how can we assess if we really have a long-term problem with tacit collusion? So that is really tricky, the topic of the threshold. It has to be flexible and open, but it needs to ensure some legal security and predictability. So that is really the tricky thing here when you do this legislation. But on the other hand, it's really interesting if you try to draft this and sort of tackle it from the other side, not looking at an infringement, looking at certain characteristica. that are taking place in the markets. So that's also something really interesting, and I've noticed that our economists, for example, in our agency, are really fascinated by taking this new approach. And from our national experience, but I think we'll talk about it a bit later, we also see a need for this.
Exactly. So let's continue with Silke. And I hope the connection is good. The same question to you, Silke. Do we really have the enforcement gap at European level that really justified a new competition tool? And what would be the appropriate threshold according to you? Do we have the first technical problems? Maybe before we... maybe the same question to Marike, and in the meantime, I believe that Silke is going to fix the problem with the microphone, I guess.
Good evening.
Good evening, Brussels.
Hello, I'm very happy to be here tonight. I mean, not there in Berlin, but just at least to the live stream. And I would have loved to come to Berlin, but these are very strange times. So this year it was not possible, but at least I can participate in this way in the discussion. So I understand you're asking me the same question you had for Silke. So what's
exactly? Do you see really a clear enforcement gap that must be really addressed as with this complementary tool next to the ex ante?
Yes.
And what would be, according to you, the clear threshold, having in mind that the established rules that we have in different fields with regarding dominant position?
Mm-hmm. Let me maybe start with a bit of context. So, I mean, the proposal for a new competition tool is one of the measures that our commissioner announced at the beginning of the year to ensure fair and contestable markets. So the pillar, or the first pillar, the main pillar, of course, remains a vigorous enforcement of competition law and trying to go also further there. I mean, improvement is always possible through, for example, a stronger use of interim measures in appropriate cases, and potentially also more restorative remedies where there is a need for those. In addition to those, I mean, we've always said competition law is not a panacea for all market malfunctioning. So you also need additional measures to tackle certain problems in markets to keep them open and contestable and competitive. So in addition to that, a complementary measure is to introduce ex ante rules for very large gatekeeper platforms. That's what our commissioner always refers to as clear do's and don'ts, to tackle certain unfair practices or proven harmful conduct. And the third measure, or the third pillar in this approach, is the new competition tool to complement these two pillars to address structural competition problems that cannot be covered by the current rules or cannot be addressed in the most effective manner. So it's not really an enforcement gap as such, it's really complementing a complementing element, a reinforcing element in a toolbox of three different measures that would work towards the aim of ensuring fair and contestable markets. It was already mentioned, I mean, there are certain elements or certain structural competition concerns that we cannot tackle at the moment. Tacit collusion was mentioned, anti-competitive monopolization strategies as well. So there are different scenarios that the current rules cannot cover. In particular, if it's about conduct by non-dominant players with market power that maybe are on the verge of getting there, but they don't fulfill yet the concept of dominance under competition law. And then on the side of things that you cannot tackle as effectively, an example that we are always giving is parallel repeated leveraging into adjacent markets. So for these cases, of course, you can run a case under Article 102, abuse of dominance, and we've done a couple of cases. The problem is that if you have this conduct occurring in a repeated manner, you have to run a separate case for each of those instances. And that, of course, takes time. So if you were to address this problem from a more market structure-based approach in a holistic market investigation that covers the core market from which the leveraging is taking place and the adjacent markets, you can really take, as I said, a more holistic view of the problem. You can come to a principle-based remedy, and you can also look at the source of the leveraging in the core market. And these things are not possible in the current setting if you have separate cases dealing with that, apart from the time factor, of course. So that is clearly where the new competition tool could come in and could help to tackle certain problems. And now coming to your question about the legal test, I mean, it is about market structural features that are not caused by the firms, but they can be reinforced, of course, by conduct. But all of this needs to have an outcome or an effect on competition. So there needs to be an inefficient market outcome in that sense. So there's no automatism of saying there's a structural feature that leads to certain developments and automatically you would have to come in and remedy that situation. It's really about making the link of how does that affect competition in a particular market. In the UK, the test they use, the concept they use is adverse effect on competition. I think it will have to be something along those lines, right? Where really you have to prove what is the effect on competition in the market you're investigating. It needs to be, as was also said by Natalie, a concept that's sufficiently encompassing. I mean, in the same way as abuse of dominance, right? It's a concept that has to be filled with life. But you need to be sure that you can cover different scenarios under that all amount to a similar problem. But of course, it needs to be a predictable test. So there needs to be a way to make clear that market players understand what you're looking out for and what possible theories of harm could fall under that. So the CMA has done that, for example, with guidelines. In Article 102, you have a list of practices, which of course are not exhaustive, but examples of what an abuse of dominance could be. So there are really different techniques of how you can do that. But what is clear is you have to have a clear test and a predictable test. Make sure that that's a workable instrument.
Many thanks, Marike, for this statement. Maybe we should try again with Silke. I hope in the meantime the technical problems are fixed. Silke, do you hear us?
Well, I hear you. Can you hear me?
Perfect.
Oh, that's great. Because wonderful. Okay.
Perfect. I thought maybe you're still in the federal cartel office, and maybe because of some strict restrictions, but that's not because of that.
I'm at home, as you can see. My office in the federal cartel office does look a bit different.
So there is. I can promise you there is no danger of any data leak in the meantime of current ongoing antitrust procedures. So we can freely speak tonight.
I just want to mention maybe your technicians can do something about this. I'm hearing everything double, but with about 1 minute time difference. So I'm very strange.
Maybe
I'm trying to concentrate. Huh?
Yeah, all micros must be switched off for those that doesn't speak currently, please. That's the only remedy I can recommend at the moment.
Okay.
So
maybe to the question whether there is an enforcement gap. I think that the discussions that we are having had in the last years and picking up in the last months, I guess, about digital economy and the question of how we solve the issues there does show that there is a sort of gap. I think from our perspective in Germany, we would say that the discussions that we have been having here for the 10th amendment of the competition law also show that there are things that you might do in order to be able to tackle these issues more effectively. And from our point of view, I think I can say we are very glad that the Commission is proposing these two approaches and really is discussing now about how to be more effective in these areas. So, and then, of course, in Germany, we have a long tradition of also looking at markets which are not yet dominant and where nevertheless there might be problems with competition because our abuse control allows for interventions even below the threshold of dominance. And what we understand from the ideas around the new competition tool is that this might also be an option with the new tool if there is a structural competition problem which would need to be defined, of course. So I think it's good to talk about this. I personally would not think that for something like the new competition tool, it's easy or makes very much sense to define a threshold, because I think competition problems in markets might arise in different sizes of markets. So I think this concept of threshold is a bit difficult to put in this model. And I think the next task now, and I very much agree with what Natalie and Marike have said, is that we have to, of course, define structural problems, competition problems more specifically now in order to make it a legal tool, because until now I think it's more an idea, and we need to put more flesh on it, and that's why we are discussing these issues now in a broader public.
Many thanks for your initial statements. From the perspective of a potential gatekeeper, Ben, are you listening to us? Do you see enough legal certainty in the new competition tool? And what would be your comment on this regarding the threshold and the potential enforcement gap that we currently have in Europe?
Well, thanks for having me. I hope you can hear me well.
Perfect.
Well, I think we need to separate things here, right? We're on the one hand, we have the new competition tool. On the other hand, we have the gatekeeper regulation. And so far on this panel, we've been focusing on the new competition tool. And we've come out in strong support of the new competition tool because, as all my co-panelists have laid out, there are some features of markets that currently cannot be tackled by competition law effectively. You can have markets where there's no abuse or not even a dominant company. You still can have a market that's not really tending towards effective competition. And if you look at stuff like consumer inertia, consumer myopia, high switching cost, barriers to entry, I mean, all the stuff that you can find in your average competition economics textbook can tell you the conditions that you really need to be looking for. So we think it's good that the competition is tackling these issues, and we would like to see a very broadly applicable new competition tool. So I would actually put a very low initial threshold to start a market investigation, because I think a market investigation is actually a good way to generate knowledge about markets, in particular about highly dynamic and fast-changing markets, before you take decisions that have potentially very far-reaching consequences. And I think you can only make your decisions better if you have a lot of information. And I also like to believe that with the maybe less adversarial procedure of the new competition tool during the market investigation phase, companies and authorities could come to a better joint understanding of how markets are developing and what the big trends are and what this means for competition. And again, I think this is in everyone's interest. I'm a little bit more skeptical when it comes to tipping markets. We've not really touched upon this yet, because I think I'm the sole economist on this panel. And of course, as an economist, I have to say, you can have efficient tipping, even to monopoly. So I think we need to make sure that whenever we look at tipping, it needs to be clearly linked to anti-competitive conduct. And then I definitely see a use for the new competition tool as well. Final remark in this initial round: we would really like to see a broadly applicable new competition tool. So not just applicable to the digital economy, but across all sectors. And that is one of the options the Commission has put on the table. I'm a little bit worried from the latest leaks that we've probably all seen that. Maybe the Commissioner is more tending towards a less courageous approach. It's a little bit short-sighted, and it would definitely take away from the overall rationale. So I hope we get to a new competition tool that's really applicable to all markets in a very broad.
Many thanks, Ben. I have a concrete question. I would really kindly ask you for a short answer. Should the new tool be designed to address only harm that is already happening due to structural market failures and can therefore be evidence? Or should the new tool address harm that is hypothesized to happen in the future due to structural problems on the market? Maybe Natalie, we can start with you.
Thank you. First of all, if you mean it in a way that it should not be limited to dominant, to a situation where you have a dominant player in the market, then certainly I think it should be broader. Because we do see that especially these structural competition problems come up also in situations where you wouldn't find a dominant player in the sense of the current definitions. Also, you have to keep in mind that there might be irreversible damage if you have to wait for a scenario to materialize, but there have to be clear indicators for the theory of harm, so it can't just be a fantasy. It has to be something that you can grasp almost. So I think there you need to strike the balance with predictability of what authorities do. Although I just have 1 minute, right? But I don't think that competition authorities would have a tendency to go too deep into regulatory in a regulatory manner, because competition authorities would tend to, I think, restrain themselves also to very to scenarios where they really think that the damage could materialize.
Okay. What would be the comment by Marike and Silke and also Ben on this issue regarding the potential harm or actual harm that is happening? Marike?
Okay, happy to... Silke first?
Yeah, you take it, please, Marike.
Okay. No, I'm happy to go. I mean, my reply, of course, is clear, because our proposal covers both. Structural risks for competition and also the structural lack of competition, which is the malfunctioning of a market. So the difference being in one scenario that the harm is about to hit the market but hasn't caused harm yet, but is very likely to arise, and the other one, of course, where the harm has already occurred. And in the first scenario, so in the risk scenario, I mean, it is tricky to make sure that you do not intervene too early. It's important to really find the right balance between the benefits of keeping a market open and a risk that there could be a too early intervention that could harm innovation and investment incentives. Of course, I think that's something you have to balance in some way or the other, and of course you have to look at indicators. It always depends on what problem you're solving. I mean, you can have a situation where you already have a benchmark in other national markets where dominance has been reached already, and other national markets where the same player is operating and the same structural characteristics are applicable in the market, where, of course, you would have to sit back and wait if you were to go for an approach under the existing competition rules. That, of course, is an easier scenario, I guess, than if you have a global market or an EUA-wide market where you have to find a benchmark to understand when there is really a risk for competition and a need to intervene early.
Many thanks. Silke, please.
Okay, yes. Can you hear me?
Yeah, perfect.
My first question. Okay, good. So my understanding from this tool is very much that you might have to think a bit more from the remedy side. I mean, from what you would be imposing on market participants in order to alleviate the problems or the tensions that might be there. So we're not thinking about telling people that they've done something wrong and we want to maybe impose fines, etc. All of this is not part of this tool. It's about thinking and coming up with ideas on how this market will function better in the future. So it's not, I mean, I agree with Marike that we should not intervene too early, but I think it's not so much, I mean, all that we would want to be doing, I think, is to make sure that innovation would be able to continue, but not only by one, but also others possibly. So making the market work better. And so I think it's not so much the question here whether we intervene at a point in time when harm or abuse has already taken place, because that's the whole story about trying to make these markets work better, actually.
Many thanks. Ben, who do you expect to be the first target of the tool? The GAFA markets have already tipped and they won't tip again.
Oh, that's a good question. I'm not sure I'm the right person to answer that question. But maybe I can say, because maybe that's what you're implying with the question. Are we afraid that we could be potentially a target? And then I can firmly say we're definitely not afraid, because we think this is a valuable tool, and there can be a lot can be learned from having market investigations. I think it doesn't come as a surprise that when I say, maybe in the past we haven't always been 100% happy with the way some investigations into our business have been run, and there haven't been, and from, at least from our point of view, the authorities have not fully understand the market dynamics and the important features of competition that's taking place in our market. And my hope is really that with such a tool, we could get a much better understanding, because there are no fines in the room. It's at least in the beginning, as I said, much less adversarial. We're definitely not concerned about it at all, and that's why we put our support behind this tool.
Many thanks. I've already mentioned that I'm not alone in this moderation, and I hope Louis haven't left me. Louis, are you listening to me? Perfect.
Always.
That's good. You have many thoughts on the new competition tool. What would be the most worrying thing that you would like to address?
Well, I think it's clear that there's certain market phenomena that fall between the gaps, and that's what Marika's been talking about: tipping markets, entrenched competition problems, which with the current tools are difficult to land a glove on. So I think it's fair that there's some innovative thinking about how to do that. I think the difficulty is, and we saw this from the last panel, is how does this NCT fit alongside the gatekeeper legislation? How do they fit together, both conceptually but also organizationally? What's the hierarchy between them? And I'd actually take that one step further. I'd go NCT, the gatekeeper legislation, then you've got other sector inquiries, and then you've got Article 102 or 101 investigations. There would be, for certain kinds of companies and conduct, it's clear that they will fall into certain pots. But for other conduct, it could fall into one pot, in May, and in October, it could fall into another pot because a market is tipped or is tipping or whatever. And I think, so my question is, how do you give clarity to companies about which of these tools is in play? Do you leave it discretion to the Commission to decide which is the best tool at any one time, which I think is probably fair? But then a company might not know if it's going to be hit now with a sector inquiry, tomorrow with a NCT, tomorrow with a gatekeeper, or then with a 102 probe. I just wonder how. I don't expect Marika to know the answer to this because it's obviously under consultation, but maybe Ben's got a view on whether there's uncertainty there.
So maybe we start this round with Marika and then Natalie and Silke.
Okay, happy to go first. No, indeed. I mean, the consultations are still ongoing, so it's difficult to say what's going to be the final outcome, but the objective is what I said initially, to come out with a proposal that is complementary between the two pillars, so between the DSA initiative and the new competition tool and the existing competition law. And if you look at 101, 102 and the NCT proposal, as I said also initially, the main focus is on areas that we cannot cover under the existing rules. And there may be that, small overlap of cases where it's about doing things more effectively because you can take this holistic market-based approach. But I don't think that there's going to be, there would be a lot of situations where you would be deciding between the two because they're having a totally different approach and focus. I mean, the NCT is really based on a market structure-based approach, looking at if it's for the risk scenarios, ensuring that markets remain open and ensuring contestability. And for the other, for the scenarios of where you have this overlap, of course, it's really taking a different approach from what you can do under competition law. And the NCT does not have a conduct focus. So in this sense, I don't see a problem with having these two working in a complementary way. I don't think it would be helpful for the effectiveness of the tool to have a kind of decision moment where we would have to explain why we don't use 101 or 102, because that's what some people have suggested. I mean, if you request that, it essentially means that we would have potentially to litigate before even being able to start a market investigation, whether we are allowed to investigate, because there are indications of a structural competition concern. That would be very difficult, and I don't think that this tool would then have any practical importance or relevance in our toolbox. So I think that there needs to be, at least to that extent, discretion. But of course, if there is a scenario where the two could overlap, I think we have to explain why we believe that a market structure-based approach is more appropriate. And then we look at that particular market from this NCT perspective, do the investigation and prove what has to be proven to the requisite legal standard under the tool. So I don't see an issue there. Then when it comes to the DSA, of course, I think the benefit of legislation or regulatory solutions is that they can, bring clarity, immediate clarity, and a quick solution to the market, because you can really look for clear-cut do's and don'ts, as our commissioner always says, so clear-cut prohibitions or obligations. Obligations may have to be tailored, of course, to a particular company, because we've heard in the previous panel that business models are different. So, you really have to look at how a particular obligation would then have to be implemented. But that's more a question of implementation and not a discussion about what's the theory of harm or, what kind of problematic behavior am I seeing. So from a competition perspective, based on the experience we have with the enforcement, the complementarity lies in using, the strengths of a regulatory solution that's clear-cut, quick, and gives immediate clarity, and then everything that requires a case-by-case assessment from a competition perspective, because you're not sure about the effect that a certain conduct or a certain market structural issue has on the market, either under the competition rules, if it's a conduct focus, if it's an abuse potentially, or from a market structure-based approach under the NCT.
Many thanks for your clarification. Natalie, how do you see the interplay of too many tools and the issue of legal certainty in this respect?
I think it depends a lot on how the tool actually looks like at the end, because there's less overlap. If it's a broad horizontal kind of instrument, then you might see less overlap than if it's a very narrow instrument, which is also tailored towards maybe specific companies. So it depends a bit on that. And then I think you have to differentiate, on the one hand, the question, how much discretion does an authority have to choose a tool, and under which conditions would it use which one, and should it give guidance? And then on the other hand, you have to look at procedural safeguards, like if the information that is given under this instrument, which is not an adversarial procedure like in 102, what can happen with this information? So there are a lot of procedural issues here, and where safeguards will be put into place, I guess. Although you have to keep in mind that it's not a procedure that is aimed at finding an infringement or a fine, so we're not in this quasi-criminal regime, so it's something else. But I can share that within our agency we had a very open discussion about the tool and the different options and what we think about it. And we tried to think about scenarios and cases and sectors that we've looked into, and whether what would we have done? Would it have been a useful tool or not? And it seemed to us pretty clear-cut. Only in very specific scenarios you would see, okay, we have really this structural problem in the market. We cannot solve it with the tools we have, although there might be a need for it. So in our discussions, we wouldn't have seen much of an overlap. It seemed pretty clear to our teams in what kind of scenarios you would go for it. When you look at it from a more practical and not a theoretical side, but you think about what cases have we done, what markets have we looked into.
Yeah. Dear Silke, are you sharing the view of Natalie as a national regulator, so to say?
Yeah, I mean, I think I share Natalie's view, but also Marike's view, and I think actually, I mean, in our discussions on this tool, we've always put forward that from our point of view, it should be really, it's necessary to to have a clear complementarity between instruments, because and I think that was part of the discussion in the earlier part of the conference that Philip, I think, said. So we don't want conflicting competencies. We don't have any time for that, discussing about who's more competent, people who are imposing or enforcing the DSA or the competition authorities. I think we should really concentrate on enforcement measures that have a real impact and make these work. So I think it's very necessary to come to very good complementary tools so that we don't have that in the end. But if we have that, such a regime in the end, I think also that these tools can very much profit from each other, because in my view, for example, many of the digital market issues that we've been looking at in the last years might, in cases, but also outside of cases, all the discussions that we are having could be good issues for a new competition tool, for having a market investigation, for looking at structural problems in these markets, where you would then come up maybe not with the necessity to really have a prohibition decision on a specific conduct, where we might here and there not be sure yet. I think somebody said in the course of the debate, what is self-preferencing? There is so much debate on what it is in effect. That might help to come to solutions to make markets work better. And that might be easier also for the companies that we are talking about here to come in a debate with us if they do not have to fear fines, even though the fines that we are imposing on these companies currently might not be so much of a problem for them. But an adversarial procedure is always something completely different from a non-adversarial procedure. It makes it easier to come to get into a debate with the company on better solutions than if you have an adversarial situation.
Many thanks. In order to have more time, to have enough time for the last session, we'll finish this session like in 10 minutes. Maybe there are some questions in the audience. Please keep it shortly.
In 2019, Margarete Vestager had a competition law conference, and one of the great keynotes there was from Jean Tirole. He was a Nobel Prize winner in economics, and he pointed out that there is a part of the regulatory measures that lies outside of competition law. This is also something that we have discussed in the last 3 panels, but we couldn't put the finger on it, what that part actually is, right? We've looked at it from a scientific standpoint, and we think that a large part of the market output can be explained with regular market failure diagnosis tools. Information asymmetries up to adverse selection, external effects, public goods. So the whole range of market failure, we thought that there's, when we check the digital markets, we find ample evidence. Now, what I'm a little startled about is that if the diagnosis is market failure, then there is an economic rule book that we seem to have tossed out of the window how we deal with information asymmetries and adverse selection. There's an economic rule book, how do we deal with external effects, and how do we deal with public goods. So the question, in order to come around towards the question towards the people in the panel is, do you think that we have this market failure, and why are not we applying the textbook rules? Because we did, and we have come up with solutions to some of these issues, like the liability issues, for instance, that we think are very capable. So why are we not applying the standard market failure rulebook to this range of problems on top of the competition law issues? Thank you.
Questions goes to your preferences.
Ms. Marike Schake and well, everybody else who thinks they want to answer.
Marike, the pleasure is yours.
Thank you. Okay. Well, if I understood correctly, that was a pledge for actually more regulation, because if I understood correctly, it is about things that cannot be tackled under the competition rules, and where you have a systemic issue, so a systemic market failure, and why we aren't regulating more. well, I mean, that would then be part of what's, being looked at in the moment in the DSA work stream, where we're trying to see which are the systemic issues that would require such a reply. So that's all I can say to that. But maybe the question was broader and was actually referring to other areas of law. But maybe others have some comments on that as well.
Okay, we have one more question. We have a guest from London, and really appreciate it that you're with us. Please, Chief.
I say that's a great way of getting everyone to stay away from me from now on.
No way.
I was going to say this. Look, I have a media background, and as a journalist, you sort of realize there's this concept of chilling of free speech, right? So it's an action that takes place off in one corner, and then everyone else gets affected by it. It's very hard to detail exactly how that happens. So it's a nebulous concept. But there's a chilling of innovation as well when you have these giant monopolies, because often when you go to these companies who are sort of downstream in a vertical, their strategy, they might not shout it from the rooftops, but you figure out their strategy is just to get bought out, right? Pose enough of a threat to the players at the top, to the player at the top, and hopefully they'll get bought out. That obviously chills innovation because they don't want to do anything else except get bought out and just pose that enough of a threat. How do you measure something like that, the chilling of innovation? Because that's quite difficult, it's quite abstract.
How do you measure this? We are asking for effect-based approach when it comes to the new competition tool. Who would like to comment on this? I think the message has been understood quite well, but
maybe can I?
Maybe Silke, okay, please.
I mean, you're asking about killer acquisitions, and the question of, from my understanding of your question, and whether we know how to measure whether an acquisition is a killer acquisition or just a normal one. Difficult. I think nobody of us has until now been able to put its finger on one of these. And from our understanding also, the large tech companies that go into buying lots of small companies that come up with new software ideas, or whether don't know yet whether this is going to be a success either. So I think it's difficult to say whether this is really a competition problem or not. And I think you can see that until now, as far as I know, there is no competition regime where we have a provision for such an intervention possibility of competition authorities. Having said that, maybe something like the new competition tool would at least make it possible to look at these things again and intervene at a later point in time. I think, Pento, you had said, what is the sense of intervening in markets that have already tipped? I think there is a lot to do there and to try to at least alleviate the situation. I mean, we're not going to put our hands in our down because the markets have already tipped. I mean, we will be asked also to come up with solutions for these situations. And of course, if we have a tool like this new competition tool, all the more.
Okay, Natalie would like to add something? Yeah,
just like to add that one thing is, of course, how do you even get to review such a transaction? And for that, at least in Germany and Austria, we have this transaction value test. But even with this instrument, we are not sure if we really get to see those kind of critical killer acquisitions that might be out there. And then another thing is what we try to do is to really, in our assessment, to get a good look at internal documents and really try to get an idea what is going to happen. But it's extremely difficult to really look into this crystal ball and see, as Silke said, even some the companies buying those don't really know exactly how innovative and successful those startups might be or not, and their ideas. So, but I think authorities are trying to get there, and we certainly try to do that in our investigations and assessments in the merger process.
One more short question, Thorsten, please.
To make it very short, just to give you a concrete example, just during Corona crisis, one of the governors who's offering infrastructure is giving loans to lots of startups for a very good price so that they can still use their infrastructure with one clause in that. If they will cancel the contract with this company, they have to pay back that loan at once. So that's the power of liquidity, which is heavily misused, not to buy one startup, to buy a bunch of them and just to see which one will be the killer app, and then you are too late.
Good example. Many thanks. So I think we have reached the limit when it comes to the time. I really appreciate your view on the subject matter. Still, I would like to hear your final remarks or recommendation, since we're approaching the process of legislation till end of the year, and maybe we start with Ben. Then Silke, Natalie, Marike, and of course the final comments by Luis.
Sure, happy to offer some final remarks. So, I mean, we are anxious and excited for the Commission proposals to come out by the end of the year. Maybe there's also some worry in there when it comes to the gatekeeper regulation. Because I think here it's going to be crucial to get the criteria right, to make it not too broad, and then also we obviously have to see how the interplay is going to be with competition law in that respect. But I mean, in general, I think it's worth highlighting that when I look through all the panelists of today's panels, there's a great degree of I think we all share the sense that there are some problems out there that need to be tackled, and it's good that something is happening. And then, I mean, as it is always, the devil is in the details, and I'm sure we're going to have some exciting discussions for at the end of the year and then throughout the next year.
Many thanks. Silke, please.
Yes, thank you. Well, as I said, we are happy that this discussion is now taking place at European level on both issues. We are very much in favor of clear delineations of instruments and competences between different sectors of law, especially, I mean, within the ECN, we have possibilities of dealing with parallel competences, but I think this is a different issue with regard to the different areas of law. And we hope that all of this is going to help us to implement better competition mechanisms in these markets.
Many thanks. And maybe to speed up the procedures in general.
Well, part of it.
Part of it. Part of it. Natalie, please.
I'm very optimistic because when I think about what was on the table at the beginning of the process, and if I look at the content of our very constructive, I think, discussions with the Commission, which we're very thankful for, I think it's a very good process, and they're looking for all the input they can get, also from the national authorities, and we're getting somewhere here. So I'm very optimistic about it. I think it's a great opportunity to make competition law work for scenarios where we didn't have a tool up to now. And I think it's a possibility to meet also some expectations to what we want from competition law enforcement in the future.
Many thanks. Maybe, Marike, you can tell us something regarding the time frame. What do you expect this to happen? And your final thoughts.
Mm-hmm. So we are at the moment finalizing the evidence gathering phase, and we hope to be done with that soon so that we can publish the results of the different work streams and also the expert advice that we have commissioned, so that everyone can see what we have been working on during the last month. And the possible legislative proposal is still scheduled for the end of the year. So there's a lot of work ahead, and we promise to work very hard to make that happen if that were to be the decision. And I can just, repeat the commitment to come out with a complementary proposal that really explains to the market how these different, legs or pillars will work together. to give a coherent and consistent reply to the challenges we're facing at the moment.
And I truly believe that our study helps you a bit, at least in this direction.
Absolutely. Thank you very much for that.
Luis, it's again the pleasure to summarize some thoughts regarding this tool.
Look, I think there's been clearly a gap identified, and the Commission should be applauded for trying to fill that with a piece of legislation. This is not easily done. It's much more difficult to construct such things than it is to destroy them, as the conference circuit usually attests on these things. And the sign that people realize how powerful it could be is in the arguments you find over the scope of it. You know, a lot of people don't want this tool to apply to them. I think the nuts and the bolts are going to be in the threshold for starting one of these, the threshold for intervening, the kinds of remedies. I think there'll be a lot of litigation over that, and Marika can look forward to that in the years to come. And finally, I think one of the big questions, the criticisms, the complaints that you hear is, if you look at how the UK does this, these are non-adversarial procedures, as Silke said. Non-adversarial means more transparency, means publishing the submissions, means being out there and being open about what's going on. And that hasn't always been one of the great fortes of the European Commission, to put it euphemistically. And also, defence rights is a classic. You look at these cases in the UK, they get litigated every single step of the way. There are litigations about the interim reports, about the information gathering, about the remedies. Will the European system with its court review be set up to manage that? I think that's another big question.
Perfect. I had the pleasure to have the best co-moderator from Brussels. Really, I'm always fascinating by your thoughts and your comments in Emilex and on Twitter. And it was really a pleasure to discuss with you. Of course, my special thanks to the speakers and for coming also from Vienna, especially to Natalie. I have the understanding, of course, that Silke and Marike couldn't join us this time, but we really appreciate your view on the subject, and we're really grateful for that. Many thanks. Have a beautiful evening and continue. Please follow us in the coming session. Now we have small break of 10 minutes, and then we continue with the most difficult issue.